with the search warrants needing to be saved because as they what's up Truth Team, it's your girl Mickey Truth, SC's number one urban blogger and the queen of paperwork. A few weeks ago we were right here having technical difficulties listening in on the appeals hearing for YNW Melly. And we have been talking about this suppression or the suppressed evidence for a couple years now. And I told y'all, well, let's just do a review and then we'll get into it because the appellate court has made a ruling. Let's get into it.
We have Mickey Truth.
Who is this? You got Mickey Truth kicked out.
Shout out Mickey.
Let's get one thing clear. This your girl Mickey Truth.
So this is about all of the affidavits for warrants that Judge Murphy threw out, right? Remember, he said, hey, it was too broad, okay? Y'all want all this stuff from up here and all that. He narrowed it down. We went over that breakdown, I think, on live when it first happened. I have yet to find live. We might do it again, but this is important. And I will say this, because the last part that the prosecution was saying, if you have all these independent sources, okay, that basically have this information, why are you going so hard to keep the affidavits in or keep the information? Because if your independent sources, Polo, Moretti, if they found all this information, regardless, if you got this phone, all this information in one of the victim's phone, then why are you going so hard, meaning pushing trials back and stuff, going to the Supreme Court over it? I told y'all from the start, I felt like the new prosecutor, I can't remember her name, that took Bradley's spot. When Judge Murphy denied her motion for more time because she was new to the case, I felt like she took this to the Supreme Court, the appellate court, because she wanted more time. I don't think it has nothing to do with the search warrants needing to be saved, because as they just said, they already have these details per other things that Melly can't contest. I think it was all employed by time. I've been saying it, and I'm really locked into the conclusion now after hearing that. Because why go through all this if you can still Buckaloo, boom, that's her name, okay? So I felt like this was the only legal way to get more time after Murphy, okay, denied her motion for more time, okay? All right, so that was my reaction to that then, and it's still my reaction to that. But we're going to get into what did the appellate judges feel, okay? Was I in warrant one or not? I don't know, but we're going to get into it. Y'all already know we're not going to go verbatim through the document. However, I have came up with a summary so that we can just come into a conclusion quickly, okay? This is a 5-page opinion. Y'all know that's what it's called when they give their response to a case in the appellate court. You can go view this publicly, okay, for the Court of Appeals in Broward County, okay? So, again, we just went over my opinion of what we heard in the arguments, okay? And basically, the state of Florida appealed a decision made by the trial court that suppressed evidence obtained through multiple digital and social media search warrants. The lower court had found those warrants too broad, meaning law enforcement went beyond what was legally allowed when searching Melly's data from platforms like Snapchat, Instagram, Facebook, Gmail, and iCloud, okay? Now, instead of throwing everything out, Judge Murphy narrowed the warrants, limiting the evidence to the time right before, during, and after the murders, which occurred in October 2018. The state argued that even if the warrants were flawed, the evidence would have been inevitably discovered or found through independent sources. But the court rejected that, calling the prosecution's claim rank speculation. Yeah, like I told you, I think it just was a way to get more time, okay? Now, the judges decided. So the appellate court agreed with the trial court, officially affirming the suppression order. The judges backed the lower court use of severability doctrine, meaning that even though parts of the search warrant were unconstitutional, the judge had the right to cut out the invalid sections and keep the parts that were valid and relevant. They cited federal precedent. I know I said it wrong, but okay, cases like United States versus Gapland and United States versus Sales, saying this was the correct way to handle overbroad digital search warrant. The court also agreed that time-based limits, like focusing only on Melly's location around the time of the murders, were a proper way to restrict the warrant's reach. Okay, now why? I mean, why does it matter? Like, why is that important? Okay, legally, why is that important? Okay, so the ruling means the defense scored another legal win. As the appellate court refused to reinstate key digital evidence the state wanted to use. The decision also sets a strong precedent in Florida, showing that courts are cracking down on overly broad digital warrants and major cases involving cloud data and social media. So for YNW Melly, this decision helps limit how much digital evidence can be used against them if the case goes to trial again, especially material that's outside the hours of the shooting. We are going to take time to get into that. I just have to find the time to actually, y'all know me and my PowerPoints, okay, and break it down. And I actually have my old PowerPoint from when we did the timeline of it. So I may just start there and look back through the documents to see what is out and then redo it. But it's going to take me some time. Yeah, but we're going to get to it, okay? Because as of right now, they still haven't said an actual date for the trial, okay? Now, if we look down here, this is, okay, oh my bad, y'all can't even see that. This is here, okay, for the double murder case, okay? Now, it says here, we do not reach the evidentiary ruling regarding adaptive omissions on a promotional video, as those rulings are part of a non-final, non-appealable order, okay? So let me see what other footnotes. Okay, that's y'all know I love reading the footnotes. Okay, some of the cases I already told y'all about. All right, so it's another opinion that they made public. Okay, and how you know it's a difference is the last four numbers. Okay, of it. All right. So what is this one about? Okay, so again, this is opinion based on the decision to take out some of the information that was obtained through the search warrant affidavits, okay? It again connects directly with the earlier ruling we just went over, where judges sided with Melly's defense and upheld the suppression and overbroad digital search warrants, okay? So this again confirms trials court ruling stands. The digital evidence the prosecution tried to get back into play will stay suppressed. So basically, again, the appellate court and say, hey, shout out to y'all for trying to overturn this, but no, we're not doing that. It's affirmed, meaning we're standing with it, okay? The court didn't see the need for further discussion. The prior ruling already made the state's position clear. The search warrants were too broad. The trial judge handled it correctly by cutting out the illegal parts, and the evidence stays out. Hell, they should have just tossed everything, to be honest, because they knew that was too broad. Okay, just basically that. So that's basically what that goes into. That's big. All right, let's see if it's any footnotes. No footnotes. So yeah, it's just basically. So basically, it goes with the other case, the witness tampering. So they can't even bring it in on that. Because remember, they was trying to put everything on the witness tampering case to keep it out. Because I knew, to me, my opinion, they messed up on the murder case and they was trying to make it up on the witness tampering. But the evidence stays out. Now, again, according to the state, they are still able to prove everything, even without these warrants. So it's going to be interesting to see how that plays out in court. A lot of that gang talk is out. Now, did Polo find this information where the defense won't be able to argue that no, he didn't find it? He basically used the search warrant as a roadmap. We'll have to wait till it plays out, y'all. But with that being said, like I said, I will work on the content for the evidence, but it's gonna take me a while. With that being said, like, comment, share, subscribe, tell a friend, tell a friend. Now pull up on your girl Mickey Truth. And y'all, side note, we do have Alicia Andrews' trial coming up next week. It's supposed to be, okay? Like I already had told y'all, I will be covering it at night. I won't be live during the day for it, but I definitely will break it down for you as normal. With that being said, y'all have a good day. I'm out.
This is the weakest. Give a fuck about what they scream.
Holla.
Shout out Mickey. Mickey, you gonna be big. Like,
I'm trying to conquer the world, coming from where I come from. Hey, this your girl Mickey Truth, #1 blogger in South Carolina. #1 blogger in South Carolina. Hold on, wait, before I go, y'all make sure y'all tap in with me to book your slot. A lot of y'all be hitting me up on Instagram and the email wanting to just talk about content, whether you're an up-and-coming content creator or somebody just got questions about cases or whatever. Book your consultation with me now. The information is on the screen. Hey, make sure you get your slot, because my slots be filling up fast.
What's up, Truth Team? I am here, okay? About to get a touch of love. Yes, I'm at Touch of Love Massage Shop, okay? Now listen, I've been getting my massages through Touch of Love for years, even before it was a shop to come to. But let me show you around, and then I got to get ready because I'm feeling a little tense. And let me tell you, if you work in like call centers, streamers, YouTubers, sitting at that desk all the time, you definitely need to be tapping in to get your massage. So let's take a tour. So it was located in a nice multi business building. The suite was set up real comfortably. It was like to the back, and the candles was burning. The aromatherapy was definitely there. Okay, so I had to get undressed, and I'm like, yo, I gotta get all the way undressed. But anyway, like I said, being getting massages, Nakia is awesome at what she does. And let me tell y'all, them hands are blessed, okay? I got the full body massage, including, okay, the hot stones. And when I say that hour went so fast, I even went to sleep. And I always go to sleep during massage for some reason. But yeah, definitely needed that, because y'all know I had a night ahead of me, okay?
Hey guys, I'm Nakia. I am the owner-operator of Touch of Love Massage Services. I always start with the information of what massage is. So massage is the manipulation of muscles. Exercise is the manipulation of muscles. The only difference is we are manually using our hands to do those activities. So a lot of people look at massage as a luxury when really it's a health necessity. So I'm more on the medical side of things. So if you're experiencing any pain of any sort, muscles is 90% of pain. So I would recommend you to come and get a massage.
How can they follow you?
I do have my business page, Touch of Love Massage Services, on Instagram. I have Touch of Love Massage Services on Facebook. And if you want to set an appointment with me, you can look me up on Setmore. It's an app platform online where you can book appointments.
Hey, there you have it. And y'all, I feel like a new woman, but now it's time to party. So I'll catch y'all in the next one.